eventually that it is a measure. UK has adopted a measure which is equivalent to a quantitative restriction, because now Spain isn't going to sell the product into UK. Do you get it?
Yes, ma'am, I got it. Thank you.
Okay. France, Netherlands is on plant protection. You can read that. I've given you the website for you to check it out. And the case of class. Swedish measure prohibiting the import of alcoholic beverages to Sweden by private individuals. So there was a Swedish measure prohibiting the a type of alcoholic beverages into Sweden by private individuals. Okay. Instead, the individuals had to ask the holder of the retail sale monopoly to supply and, if necessary, to import the alcoholic drinks in question. The court found that the measure was unsuitable for attaining the objective of limiting alcohol consumption generally, and not proportionate for attaining the objective of protecting young people from the harmful effects of such consumption. Therefore, this measure fell under the scope of Article 34 and was not justified. So who can explain class for me? What happened here? So the first sentence basically says that Sweden, okay, had a measure, okay, which prohibits certain type of alcoholic beverages to be sold in their country. Okay, right? And if they are to be sold in their country, these individuals, the people who these people who sell these products, had to ask the holder for the retail sale monopoly to supply and, if necessary, to import the alcoholic drinks in question. So they had to do something extra. They have to speak to a holder of this particular alcoholic beverages, a monopoly, this particular company, let's assume a company, they had to ask them, and then only after going through relevant policies, then only they will be able to sell these goods, this type of alcoholic drinks to their country, okay, to Sweden, right? Now, this is an extra thing that these individuals had to do, okay? And the court said, well, and they gave a reason saying that, okay, Sweden gave a reason saying the reason we are doing this is to protect young drinkers from the harmful effects of this alcohol. Court said that is okay. That is an okay reason, but it is so disproportionate. Your measure is such a disproportionate measure, and it doesn't any the health of these young drinkers. Rather, it is basically you're trying to basically ban this type of product. It's an MEQR. Okay, you're trying to stop the sale of this product. So your reasons are not therefore justified. Okay, and it was not justified under the health of humans. Okay. The court will take into account the attitude of other member states and of international health bodies such as WHO when assessing whether particular products pose a risk to health. So the court says, okay, when you're protecting a certain, when you're sort of adopting a health standard, not only will we look at how other countries work, but we will also look at international bodies such as the WHO. What are they saying? You know, what are they like, these bodies, what are they saying about a product or a certain aspect, right? After looking at that only, they will, the EU, the CJ, the Court of Justice of the European Union will justify the measure of that country, of the country that is imposing the measure. For example, in Commission versus Germany, additives in beer. Germany prohibited a large number of additives in beer, which were permitted in other member states. So there were these type of additives, these things that they add to beer, where Germany said you can't use these type of, hold on, these type of, the Germany had made a ban saying that you cannot use any of these additives in this beer, where other countries were using these type of additives into their beer. So countries that had these additives cannot sell these beers into Germany. Okay, so there was a MEQR. There has been a measure equivalent to a quantitative restriction. So what happened? The Court of Justice was not swayed by the argument that they posed an increased danger to German consumers because so much of beer was consumed in Germany. So the reason what Germany gave was like, we already drink so much, our people already drink so much of beer. So because of that, we have to limit these types of additives in beer. Court said that, listen, no, that is not a reason. So around all other member states are allowing this. It is sort of a practice, like that it has been like, there has been research saying that, listen, these type of additives are okay for the drinks. Therefore, Germany, you cannot have such an unreasonable measure, because it eventually stops other beers or other countries that makes these beers from entering your market. Do we understand that? Yes. Who doesn't understand? Are we good? Okay. Right. If you have any questions, please put it on in the chat box. Yeah. Then what happened in criminal proceedings against Ditlev versus Bloom? Concerned the protection of life of animals under Article 36. It was held that a ban on imported bees into Danish island of Leh to protect the native bee from more aggressive species was justified and proportionate. What happened here? What happened here? Anyone? Lakshika, what happened here?
I'm trying to read it out.
Yeah. Okay. Lakshika? Didn't understand it?
A little bit complicated.
Okay, no problem. So what happened here was, it was on importation of bees into this Danish island. Okay. And Denmark basically said, no, we cannot have these imported bees in our country, because we want to protect our native bees. In this island, there was a native bees, because these type of imported bees can actually, these aggressive bees, these species can kill the native bees. Okay, there's a possibility of the imported bees from killing their own native bees. Because of that, it was brought under Article 36 to protect their animals. Got it? And it was justified. So that import ban was okay. Got it? Import ban of these bees. Did you understand that, Lakshika?
Yeah, it's clear.
Okay, super. Right. Where the available scientific evidence on health impact of a particular substance is unclear. Now, there's a universal standard of certain health impacts on certain food and products, right? There are certain types of products which you don't know the health impact. And each country will take a different view of things. Okay. So when the scientific evidence is not really clear, then the benefit of the doubt is given to the country that we're speaking, and the country can have their own policies and say, okay, we don't have a particular a clear health impact, therefore we are going to ban this product because we are too afraid to have these products in our country. That is okay. Okay, but it has to be proportionate. Okay, and that you should want to protect your people, the health of your people and animals, plants, etc. So what happened in Sandoz? The Dutch authority refused to grant authorization for the importation of these certain muesli bars. You know what muesli bars are, right? These cereal bars. Okay, now these particular cereal bars had added vitamins, okay, from Germany. The sale of this cereal bars from Germany to Germany had this added vitamins. In Germany, it was lawfully sold, but when it came into the Dutch authorities, okay, when it came to the Dutch authorities, what happened? They said that, there's these added vitamins, but we're not sure of these added vitamins, whether they're good or bad for you, right? Even though there was uncertainty in the scientific research into the effects of the chemicals, such as these added vitamins, court held that these rules were justified. Okay, so what happened here? They said that, listen, we don't, the European court said, okay, we don't know, okay, whether these added vitamins are bad for you. Even though that was there, the court said, you don't have to sell these products because there is not enough scientific backing to prove that it is good or bad. Okay, do you understand that? Do we understand that? Lakshika, Dinesha.
Yes, ma'am. Yes, I understand.
Okay, right. Commission versus
Yes.
Denmark. Yeah. Commission versus Denmark. Court confirmed that member states can adopt their own precautionary measures in situations where the precise risks to health are uncertain, but said that any precautionary measures must be necessary and proportionate. So in Commission versus Denmark, they said that you can bring in precautionary measures to stop these products, and you can bring in reasons to protect the health and life of humans, animals, and plants. But whatever reason you bring should be necessary and proportionate. If it's necessary and proportionate, then it can fall under Article 36. If not, no. Okay, right. The greater uncertainty in science and in practice, the greater the member states' discretion to apply a precautionary principle. That means when the scientific evidence is uncertain, when the scientific evidence, you don't know whether it's good or bad, then it is up to the member states' policies and decisions to come up with any precautionary measure they want. So EU will allow it because there is no scientific evidence. It does not need to wait till the existence of extent of the risks are clearly established. They don't have to wait to really prove that in science and medicine that this is good or this is bad for you. The fact that there is not enough evidence, you can have a measure to stop that product coming from your country. Okay, right. Commission versus Netherlands. The court said that the proper application of precautionary. So, what is the precautionary principle? What do you mean by precautionary principle? You have to first. There are three aspects: the identification of the potentially negative consequences of health. So that means you have to prove, rather, your reasoning should be that there could be negative consequences of health. So let's talk about the cereal bars. The country could say, well, this particular added vitamins could cause a bad effect on your health. Therefore, we don't want it. A comprehensive assessment of the risk of health based on the most reliable scientific data. So they have to say the most recent reliable scientific data suggests that we don't know whether this could be bad for us. We don't know that. That is enough. Okay. Where data on the existence of the alleged risk is insufficient, inconclusive, or imprecise, but the likelihood of real harm to public health persists, should the risk materialize, the precautionary principle justifies the adoption of restrictive measures. The fact that there is insufficient data to show that whether this is good or bad for you, and if you can say that, okay, this could harm the public health. If you could say that this can harm, there's a possibility of harming the public health, then you satisfy the precautionary principle. Then you can say, well, I am taking a precaution. I don't want the negative effects of this to come into my people. Okay, do we understand that? And who has to prove these three principles, the precautionary principle? The member state has to prove it. The member state saying, okay, we don't know whether it's good or bad. They have to say, okay, the reason we brought this policy to stop these type of cereal bars or, whatever coming into our country, it's because of our precautionary principle, and the burden is on them to prove it. Okay. Now, An example of a member state failing to prove this precautionary principle is in the case of Commission versus Italy, 2003, the caffeine case. A member state fails to fulfill its obligations under the article if it applies, article means Article 36, if it applies to drinks produced and marketed in other member states, a rule prohibiting the marketing within the territory of energy drinks containing caffeine in excess to the certain limit without showing that limit is necessary and proportionate for the protection of public health. Okay, so what happened here was that they said that, okay, we don't want this type of caffeinated drinks, which is okay, that is a good enough reason, but I mean that is an okay reason, but you have to justify it, it has to be proportionate, right? But the country failed to say, or failed to show rather, that this limit is proportionate to protect the public health. Now caffeinated drinks are allowed, but there is a universal sort of health guideline on this, and EU also has its health guidelines on this caffeinated drinks. So for example, Red Bull and whatever that has sort of energy drinks are already, like, there is already scientific data as to an aspect. So because of that, if you can't prove it, if you can't bring in extra scientific data to say, okay, we don't want this type of, this is the limit that we want, then you won't be able to justify it under Article 36. Okay, right. Okay, so we completed public morality, public policy, public security, protection of health of life and of humans, animals, and plants. 1 minute. And we have two more here: the protections of national treasures possessing artistic, historical, and archaeological values, and the protection of industrial and commercial policy. Right. Now we're going to go to the Cassie de Dijon approach. Okay, now we completed the case of Dazanville and the basis of how hindrance came into place, and we went into Article 36 for the justifications. Okay, now we come up to the second case of how this MEQR, or the notion of MEQR, is expanded, and that is under the case of Cassie de Dijon, where it had a different approach to indistinctively applicable measures. Okay, so if I go back, I'm going to here. So we completed Dazanville, and now we are coming into